The Supreme Court will now consider whether a state can put in place a Second Amendment Preservation Act with the purpose of making a state a two-way sanctuary state. But the Trump administration is asking for even more time to consider what they want to do in this challenge. So let's break down what is happening. Now, before we jump into this video, if you want to support the channel, please consider subscribing to the channel. Also click the notification bell, turn on all notifications, because that helps to ensure that YouTube will actually send you these videos. And then also just drop a positive comment down below, because that helps to tell the algorithm that you appreciate this type of two-way content and it should share it to more people. In this video, we're going to be talking about a huge Second Amendment protection case, which is once again back in front of the Supreme Court. This is a case dealing with a state's Second Amendment Preservation Act. We have discussed this case before because recently the Supreme Court issued an order denying a stay which would have protected Missouri's Second Amendment Preservation Act. After the denial order in this case, it was sent back down to the 8th Circuit, who recently issued their new decision in this case. The 8th Circuit sided with the Biden administration and decided that the Missouri SAPA law there was in fact invalid. The 8th Circuit believed that the law invalidated federal laws in violation of the Supremacy Clause. But now Missouri has filed their official petition for Supreme Court review. The Supreme Court will now consider whether they will actually grant review to this case and consider a state's Second Amendment Preservation Act and this type of sanctuary law. But now with the Trump administration back in control, they have asked once again for some additional time to file their response brief in this case. The Attorney General Pam Bondi at this point has failed to take any of these major two-way actions, really take big actions in some of these lawsuits. A lot of these lawsuits have been held in abeyance, and it appears that they're trying to do the same thing in this one in front of the Supreme Court. Now, for those not familiar, in 2021, Missouri passed a law called the Second Amendment Preservation Act, or the SAPA law. The law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce federal laws that violated the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce those type of inconsistent laws. This law also is very important because it created a civil remedy where any resident of Missouri could sue a Missouri official if they helped enforce a federal law that in fact violated the Second Amendment. The Missouri law is similar in nature to the Texas abortion law SB 8 and the recent Supreme Court decision in the case Whole Women's Health. With the Texas and Missouri law and how they are structured, you can't get an umbrella injunction against the state or the Attorney General or any of these officers or agents because they're not actually the ones enforcing the law. Instead, it's the private individuals who are filing civil suits that are actually enforcing the law. Now, in this Missouri case, the District Court on review ruled in favor of the Biden administration, striking down the Missouri SAPA law in its entirety. Now, in response, the state of Missouri then appealed up to the 8th Circuit. Missouri asked for the 8th Circuit to stay the lower court's decision, which vacated the law entirely. However, the 8th Circuit disagreed and denied that stay. That then led Missouri for the first time to go to the Supreme Court on an emergency application. However, the Supreme Court on review issued an 8-1 order denying that stay. Only Justice Thomas was in favor of granting the stay in favor of the state of Missouri and in favor of protecting the SAPA law. Now, after the Supreme Court denial, the case then went back to the 8th Circuit for a full expedited hearing on the arguments. The 8th Circuit ultimately on review ruled in favor once again of the Biden administration, striking down the SAPA law in its entirety. But now Missouri has filed their writ assert to the Supreme Court, asking for the Supreme Court to actually review this entire issue and this entire case on the merits. Now, in the petition, Missouri presents three main questions for the Supreme Court to answer. First, can the federal courts second-guess a state's reason for exercising 10th Amendment authority? Second, does the Constitution prohibit states from exercising 10th Amendment authority when motivated by a concern that a federal statute is unconstitutional? And third, is a state official a proper defendant under Ex parte Young simply because the official is regulated by a statute, or does the official also need to possess authority to enforce the law? Missouri goes on to argue in the petition that before this case, it appears no federal court had ever blocked a state from exercising 10th Amendment authority simply because of the reason the state expressed for exercising that authority. It declared a Missouri law unconstitutional solely because of the law's legislative findings, specifically the legislator's opinion that some federal statutes are unconstitutional under the Second Amendment. The court took no issue with the Missouri law and what it does, only with what the legislative finding says. Indeed, the court agreed that a law with the same effect but different findings would be permissible. As the court put it, Missouri may lawfully withhold its assistance from federal law enforcement if it picks a different reason, such as withholding resources as a matter of policy rather than as a matter of constitutional interpretation. Now, one of the things that Missouri is pointing out here is that the Eighth Circuit essentially said the structure and potential operation of this law is valid, but they ultimately struck it down because they don't like the underlying Second Amendment purpose that is included in this type of law. There was another issue where Missouri argues that the Eighth Circuit went against clear precedent because they found that state officials could be sued simply because they enforce a law in some way by essentially not taking any action. Here, the Eighth Circuit found that inaction is actual action, non-enforcement is actual enforcement, and so they could say that a state official here could actually be sued and an umbrella injunction could be issued against the entire state. Now, this law was opposed by the Biden administration, but now the Trump administration is in control, and they're trying to decide what the government's position is going to be in this case. Originally, the federal government was set to file their reply brief to the Supreme Court on February 26th, but that was extended. They got an extension of time, and then it was extended out to April 11th. But once again, you have the federal government, AG Bondi's office, asking for a new extension from the Supreme Court. The new motion states that the petition for a writ of certiorari in the above captioned case was filed on January 23, 2025. The response to the petition is now due after 2 extensions on April 11, 2025. We respectfully request under Rule 30.4 of the rules of this court a further extension of time to and including April 25, 2025, within which time to file a response. This extension is necessary because the attorneys with principal responsibilities for preparation of the government's response have been heavily engaged with the press of previous assigned matters with proximate due dates. So the DOJ is likely going to get another 14-day extension in this case to file the response. What is interesting about this request for the motion to extend the time is that it's pretty vague on the purpose of that request. Now, if they really wanted to add a lot of purpose behind this, there's a lot of underlying things that are going on within the DOJ. Of course, you have the ATF itself, which has now changed. The director of the ATF has changed. Kash Patel is no longer the acting director. And then you also have the new Second Amendment task force that's been created by AG Bondi in response to the Trump executive order. One of the other things that's really impactful for this case is the fact that the Solicitor General has now been confirmed. So we have an actual Solicitor General selected by Trump. And one of the interesting things about that is John Sauer. He was the one who was actually operating within the state of Missouri, defending the Missouri SAPA law, and now he's the Solicitor General for the federal government and potentially is in the position where he would have to oppose this state law, which I don't see that happening. I think ultimately the way that this is going to come out is in the correct way, where you have the federal government not really contesting this, saying that potentially a state could do this in some way. But there's a lot of interesting wrinkles with this where they could have asked for an extension based on some other more legitimate purposes. But in reality, what really is going on here is the AG's office is simply trying to buy more time and delay this case. We've already seen the office try to hold multiple cases in abeyance, put them off like pistol brace cases, silencer cases, other ones, essentially to try to come up comprehensively, I guess, what their game plan is going to be in some of these 2A cases, or potentially just not take a firm stance on some of these more controversial issues. Also, under the new task force, according to AG Bondi, that new task force is supposed to come up with these strategies for this type of litigation. So maybe that is something that's also going on. But essentially now the AG's office has until April 25th to give their response on and essentially answer what they believe on this type of SAPA issue. So we're going to be watching this closely to see ultimately what they do, if they try to extend this out even further, or if the AG's office and the new task force finally comes up with a legitimate stance and response in this issue. So we're going to keep our eyes on this as things develop. I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.